right. Hi everyone. My name is Andrea with Minorea-BEM, where we take contractors from contract readiness to securing a contract and outperforming on their delivery. And today I'm really happy to be able to introduce this new platform, this new space for contractors called Contractor on the Grow, along with my co-host and good friend, Kevin Mayer, who is an expert attorney in anything related to contract law, risk management, and he pretty much brings contractors and has helped contractors for years with winning any type of litigation, litigation contracts, being able to represent them in any and defend them on any case related to payment terms, contract requirements, and security. But I want to be able to introduce or give Kevin the opportunity to introduce himself and his expertise. Go ahead, Kevin.
Thanks so much, Andrea, and thanks to our friends at Minorea for providing this opportunity for us to talk to you all about the importance of contracts and the critical terms that you should have in them. As Andrea mentioned, I am an attorney. I've been practicing for over 40 years in the state of California and often around the country. And among other things, I've been involved in construction defect and breach of contract litigation, representing developers, contractors, subcontractors, and others involved in the design and construction of both residential and commercial properties. What we're going to talk about today is the importance of the contract document itself. And you might think that that's pretty basic, but if it were so basic, we wouldn't have so many disputes that arise around them. And so Andrea and I will be talking today about some of the critical terms that you need to think about in having in your contract documents, whether you're building a house, building an office building, or involved in a much larger public project.
Thank you, Kevin. Well, as you can see, this is a platform, this is a space for you, contractor. No longer will you feel alone in any type of major decision making. You can always come to Contractor on the Grow, ask the questions that you might ask, understand that the topics that we're addressing are specifically for your success in performing a project, and you have the best team in relation of helping you through the process. Especially with Kevin's expertise, you don't have to worry about having to go somewhere else and not really getting the professional advice you're seeking. Remember that Kevin is always available for a private consultation as needed, but we're always going to relate cases related to any type of specific projects, and how to properly execute, and talk about how to reduce your risk and perform correctly. So in relation of this platform, of this space of your area to be able to express yourself and open yourself in any type of situation, we're going to be talking about this incredible topic of how to start protecting yourself through contracts. So the first question I have for you, Kevin, is if a contractor is actually looking to and addressing and identifying a opportunity, what are the things that they need to look at, or also the things they need to address on their own contracts when having to perform on a project, and making sure that they can reduce risk? There's one starting point, and what would be that starting point?
So the starting point, I think, really is to understand, before we get into the various terms, what is a contract? Why do we have a contract? And it's important to understand from the legal perspective that contract law is one arena or one area of the law that is a specialty unto itself. There are multiple areas, as you can all imagine. There is criminal law, there is civil tort law, there is tax law, there is regulatory and environmental law, all kinds of things. Contracts are agreements between two parties or more than two parties that spell out each of the parties' rights, duties, and obligations under that agreement, what they are going to be doing, what they are going to receive in exchange for doing what they have agreed to do. And then we'll talk about the individual terms that help define how that contract is going to be discharged and how you as the contractor are going to be able to do the work that you have agreed to do, get paid for it timely, so that you can not only be compensated yourself, but compensate your subcontractors, and at the same time protect yourself to the extent you're able from potential legal liability for problems, mistakes, errors that may arise during the course of the job. So with that as the foundation, we can then dive in, Andrea, to the individual terms.
Yes. So that's what I was just about to say. That's a lot. That's a lot to really absorb. So let's break it down. Let's break it down to when you're reviewing a contract, an agreement. The first thing is understanding what you're getting into, which would be the scope of work. What does that involve?
Right. So when we're talking about a construction contract, Andrea, what is the most important part of that? Well, it is what we call the scope of work. What is it that the contractor is agreeing to do? And just as important, what is the contractor not agreeing to do? So the whole point of defining the scope of work up front is to identify what's included in the contract and, to the extent it's possible, what is excluded in the contract. And we do that because we want to prevent what we call scope creep. That is, more and more requirements being put onto the contractor to do things that they didn't originally agree to do and that they may not get paid for if they go ahead and do them. So the whole point here is to ensure that we have in writing detailed descriptions of what the contractor has said they will do on this project, and as importantly, what the contractor is excluding from that unless the parties enter into a subsequent agreement or a modification or revision of the existing contract in order to clarify what it is they're going to do. So scope of work, first and foremost, is the most critical part of the contract because it defines what the contract is really all about.
Yeah, and it also gives you clarity of, your capacity, right? Is this a project that's going to match my capacity at this moment? And some contractors might have, good amount of crews, but it's just the time that might not be the most effective time to start or make a proposal for the project. So some of the key elements on that scope of work is addressing payment terms. So what can you tell me about payment terms, Kevin?
Well, we do, and Andrea, you just raised a really excellent point that we should talk about before we even talk about payment, and that is know the limitations of your expertise. If you build houses, it doesn't mean that you're qualified to build a 40-story skyscraper. It doesn't mean that you're qualified to build a bridge. So understand what your expertise truly is and what your limitations are. Because just as those of us who practice in the law should not practice in areas that we are not experienced and expert in, neither should you as a contractor get into something that you're really not qualified to do. Now, of course, payment terms are equally as important as the scope of work. So you're going to do something under the contract. You also need to know how you're going to be paid for that, what you're going to be paid for that, on what schedule and under what conditions are you going to be paid. And perhaps as important to that, if you're a general contractor or a subcontractor, it's important to know the circumstances under which you're going to get paid. Is this a pay if paid by the owner or whoever is responsible for paying you contract, or is it a pay when paid obligation? So those are important things to understand. Also, often in contracts, there may be a retainage requirement. The owner or whoever is developing the project on which you are doing the work may request that there be something called a retainage, and usually it's 10% of the amount that's owed. So just to use a simple example, if you submit a bill for $1,000, they will withhold $100 of that, 10%, until the end of the job. And then at the end of the job, there's a big retainage fund. And assuming that everything went smoothly and there's no disputes about what happened, when it happened, how it happened, you should be entitled to get that back. So you need to be aware of whether under the contract you're required to provide a retainage to the owner. There may also be an interest provision that goes along with that, so that if money is being held back, the value of that money is in fact valuable, and you're entitled perhaps to be paid interest on that because you don't have it available for your use right at the outset. And then lastly, with regard to payment, there needs to be a provision in the contract that gives you as the contractor the right to suspend your work if you have not been paid and the contract does not otherwise provide to you a remedy for what happens in that situation. You should not be required to continue to work if you haven't been paid and you have no guarantee that you're going to get paid going forward.
Yes, that's something that you're mentioning, Kevin, that's so important for contractors to really look at, especially when we're talking about capacity, because the capacity is not only on the crews, the capacity is financially, right? And if an entity or a company or an individual is soliciting your services and you find out that on the terms of the contract, it's saying that you have a net 90 or net 60, you got to be planning out that amount of funding to sustain the project, to sustain you and your crews.
That's exactly right. And by the way, we face the same thing in the practice of law. Some of our clients pay on such terms, net 60, net 90, net 120. So really what they're doing in that circumstance is treating us as their bank and treating their contractors as the bank. If you've done work, you're entitled to be paid for that work, but now they don't want to pay you for 4 months. Well, unless you've got multiple streams of income coming into you and you can keep your business running during that 4-month period, you might find yourself in financial difficulty. So you really need to be aware of what the payment terms within the contract are and make them as favorable to your business operation as you can.
Yeah, and you got to remember sometimes when we're very excited of getting awarded a project or considering a project and then getting a phone call, understanding that they're considering your bid, your proposal, you get really excited about those things. And even before submitting a bid, you got to remember that there's every contract is negotiable. So sometimes for a lot of these larger enterprises, they don't know if you don't share and communicate, right? If you're a skilled craftsman, if you're a good contractor, and you can outperform on the project, you're already showing it on your proposal. Now you're just saying, hey, I want a strict net 30 pay because of this situation. It's completely negotiable, and it's not something where you're going to be condemned or you're going to be, unselected because you're negotiating the terms of your contract. And that's your right as a person that's submitting the contract.
That's exactly right. And let's face facts. In the real world, while yes, everything is negotiable, we also know that in various circumstances, we have what is called the 800-pound gorilla. And by that means somebody that has sufficient market leverage that they can often get their way in negotiations. Because if you don't want to do what they want you to do, they'll simply go to somebody else. And if you really want that job, you may decide that you really don't have a choice but to comply with what they're asking for. By the same token, there's nothing that says you can't ask for something in the contract. What is the worst thing that could happen? They say no, and then you go from there. So you have to decide, how important is this job to you, and are you willing to live within the parameters of the contract that is being negotiated?
Yeah, and then the risk that you're addressing, right? If you really want to do business with this company, and this company persists in some of the terms that you sort of want to negotiate, you gotta sometimes you got to make the tough decision of letting it go.
Right.
Because if you're not sure that you can actually perform on the project, you're going to end up even worse. And it's a fine balance.
It absolutely is. And I will tell you that in every profession, people misbehave because your contract says certain things. Remember, we talked at the outset that this spells out the parties' rights, duties, and obligations. But oftentimes, somebody on the other side will simply breach the contract. They will violate a material term of the contract, and they're banking on the fact that you won't do anything about it, that you'll continue to perform. And that's a tough thing to be in. It happens
Yeah.
to law, it happens to doctors, it happens to contractors, it happens to everybody. You're not always dealing with truly honorable people. And so you really do have to be attuned to what your rights are under that agreement and what you're able to do to either bring them to the table to perform, or that gives you the ability to walk away.
So these are decisions that a contractor needs to make as you're evaluating a contract and agreement, even before. So tell me about, speaking of like a fine balance, tell me about the project timeline. How critical is that in a contract?
It's very important because often contracts will contain something called a time is of the essence term. And that sounds somewhat self-obvious, but it's extraordinary as to how many disputes, how much litigation has arisen out of interpreting what that means under the circumstances. So when somebody says time is of the essence, that means they want this project to move quickly, efficiently, expediently, and within a specified period of time. Let's use a simple example. Let's say the contract is to build a house, and under the terms of the contract, you're supposed to finish that house within 12 months. Now, it may seem reasonable at the outset, but we all know, and we know this from long experience, that in virtually every construction project, whether it's residential or commercial, it's going to cost at least 25 to 50% more and take 25 to 50% longer to finish. That's just how it goes in the real world. But if you have a specified time limit in the contract and perhaps penalties associated with not meeting that schedule, you need to be aware of it, and you need to do the best you can to observe what you have contracted to deliver, a complete house within that 1 year period. Because if you don't, there may be financial or other penalties associated with not complying with that term of the contract. So it's very important to understand how much time is being provided for in the agreement to do the job and to address, for example, delay issues that come up during the course of construction, because they always come up and there has to be a way to address those, and to keep proper documentation of the progress of the job as you go. I know a lot of contractors don't like to deal with paperwork. None of us really do, but we have a saying, if it's not in writing, it didn't happen. And so therefore, it's important for your own protection that you keep, progress schedules in writing of what you're doing, how you're doing it, when delays arise, why delays arise. Keep communications going with the other side to let them know what's going on, how you propose to deal with it. And the contract itself, hopefully, will contain provisions that address what happens when these sorts of delays come up.
And you got to remember that in a lot of the contracts, that if you don't address and you're not finished by the deadline, then the time starts ticking against you, right? And now each day is eating off of your profitability that you had. And before you know it, it's eating off of your operation costs and everything, just because you really didn't address a delay that's maybe not related to you, right? Because there's other contractors that might be performing on the project. So you gotta be very careful on those terms as well, because like you said, there's delays there. It happens. That's part of the reality of a construction project.
Yeah,
So,
and as an attorney, one of the things that I'm looking for, Andrea, is the ability to cite to specific provisions of the contract when I am advocating my client's position. So if I am representing the contractor in a dispute with the owner, and the owner is claiming that the contractor has breached the contract, failed to perform in various respects, the very first place I go is to the contract. I want to see what the contract says, apply the facts of the dispute to the terms of the contract. And then when I'm corresponding with the owner, the owner's representative, the owner's attorney, I want to be able to cite to the specific terms of the contract in aid of advocating my contractor's position in
Yeah.
the defense of their interests.
Right. It's really important to be your buddy, huh?
Well, I tell this to everybody. Anybody that is in business, contractor, otherwise, you have to have an attorney, you have to
Mhm.
have an accountant, you have to have an investment advisor if you're fortunate enough to have funds that are available to do that. You need to have a team around you that is going to help you succeed. Doesn't have to cost a lot, but it's good to have somebody that you can pick up the phone and call or send an email to when you run into a problem and you need an answer, you need a solution, you need to discuss it with somebody to get another perspective so that you don't feel like you're alone and perhaps having to navigate issues that you really don't understand.
And this is exactly what we're doing now. There's so many contractors that even though they're small businesses in general, but particularly in the construction industry, we tend to be very excited about what we do, but we address the most important aspects as they're coming to us, and sometimes as they're coming to us, it's a little too late, right? And so having your team even before, a professional team, giving you a certain amount of advice of how what direction and what to do before you make those decisions is very, very critical for your company.
Exactly right. And the business that I am in, first and foremost, I'm a trial attorney, right? So I have to
Mhm.
go to court and argue to judges and juries about disputes between parties, whether it's contract or something else. But part of that job is what we call risk identification and risk management. And indeed, that is what the purpose of the contract is at the outset. Both sides of the agreement are identifying areas of risk that may
Mhm.
arise during the job. And in identifying that risk, they're also identifying through the terms of the contract how to manage and hopefully to avoid that risk. Or if the risk does arise, what the parties can then do to address it without having to resort to a lawsuit. That's the purpose.
Yeah, and let's continue in breaking down the contract overview, right? So we go into let's talk about warranties and guarantees. Sometimes if you don't really understand what that means when you're performing the project and in some sort of way they call you back and you have this type of warranty related, that can also pick out from your profitability as well in a very indirect way.
Right.
Can you explain that?
Sure. So let's talk first about what is a warranty. A warranty is basically a legal term for a guarantee of quality, of performance, of fitness for a particular purpose, assuring the craftsmanship that was brought to the job. It is basically an assurance that the party that is providing the warranty is giving to somebody else about their product or their service. And so there can be multiple types of warranties, and indeed the law recognizes multiple types of warranties. You may be purchasing certain products that you're going to use in construction from your vendor, flooring materials, counters, appliances, roofing materials, things of that nature. And the manufacturers of those products may be providing a warranty as to the performance of their product for a specific period of time. You, as the contractor, may be asked to warrant the quality of the construction work that you are performing under the terms of the contract for a specific period of time. And it's important to understand why this is important because, as you may be aware, in California, we have what are called statutes of limitation that apply
Mhm.
to legal claims that can be made. And so you will have statutes of limitation that apply to specific causes of action, negligence, breach of warranty, misrepresentation. And there is also what we call a statute of repose, which is 10 years in California, for latent construction defects. So if you build a house today and complete it, and the house has the certificate of completion, there's usually 10 years thereafter in which a latent defect can arise. That is a defect that is not readily apparent. And they can sue you on that within that 10-year period, depending on what the causes of action are that they're alleging. So you need to be aware of that. Just because you've gotten a C of O on your project doesn't mean that you're off the hook. That's going to tail you for a while.
Yeah.
So you have to be aware of in the contract whether you are being asked to provide any specific warranties about the work that you're performing, because that can provide an independent basis for liability. And in particular, I would caution any contractor to look out for what is called a fitness for purpose warranty. That is a legal term. And under that, you're in essence being asked to warrant the fitness of something, a product, a service, the quality of your work for a particular purpose. Well, that's pretty ambiguous. It can be whatever the person who's making the claim wants it to mean. And then it becomes a question of, well, under the law, can they maintain that claim? Do you have a defense to that claim, whether factual or legal? Well, now we're into a legal dispute, and now all of a sudden both sides have their attorneys and we're arguing over what the warranty means, et cetera, et cetera. So you just need to be aware of what these are and what the contract provides. And if you're not clear on what the terms mean, talk to your attorney.
And once the disputes start, then we're looking at identifying where to solve it, and that's when we call Kevin. That's when we call our lawyers and make sure that exactly. So when at what point? Okay, so let me give you an example. A contractor of resolutions, disputes, and where it comes. There's a typical situation for contractors where you're supposed to be you're supposed to be getting paid within 30 days. You complete the project. You 60 days have passed, 70 days have passed, and nothing. What is it that contractor Luis can do to make sure that he gets paid and he's not struggling through this financial hardship?
All right, so typically the first thing that will happen is you try to find out why you haven't been paid. And that means a phone call, a letter, an email to the other side saying, hey, I'm owed this amount of money, where is it? And see if you get a response and see if you can make it happen voluntarily. If not, the law provides for a really wonderful remedy for contractors called a mechanic's lien. You technically are a mechanic who is performing services for the benefit and improvement of real property whenever you're doing works of construction on a piece of property. So if you claim that you are owed money for services that you have provided on improving that property and you have not been paid, you are entitled to record a mechanic's lien for the amount in dispute on that property. Now, what does that mean? Basically, you have clouded title to the property. There is not clean title on that property anymore. Why? Because there's a mechanic's lien sitting there. And so if somebody wanted to come along and buy that property, when they do their title search, boom, there's your mechanic's lien. And owners don't like mechanic's liens on their property. And they might come back and threaten you and say, well, you can't do that. You're clouding title to my property. I demand that you remove it. Well, I demand that you pay me and then I'll remove it. So once again, this is a remedy that is provided to you to ensure that you can get paid, or at least start the process by which you resolve the dispute over payment.
And when you're talking about these larger contractors that you have a representative that you connect with, especially in the trade specialty contracts, right? Where you're under a GC, a general contractor, but you're performing on their project, which they are prime, and the general contractor is having a problem in making sure is throwing the ball back at you in making sure that you're still not ready to get paid. So this is a big problem because the lien doesn't really go to the general contractor that's not paying you. It goes to the entity that hired the general contractor to perform the project. So in a lot of cases, there's a situation where you got to go to the representative and you got to go directly to the source to be able to get the general contractor to pay you. You also have to address as a contractor that it's sometimes, it's still within the net 30. It's just that they're throwing the ball back at you on trying to provide one piece of paperwork or something that you sometimes didn't even know that happened, and you've been waiting for a while to get paid, right? And
Yes.
it's a simple phone call that you have to do.
Right. And you've identified a very real and continuous problem that we see all the time on any construction project, whether it's residential or commercial. And that is the payment of subcontractors. So the owner will be paying the general, and the general is typically responsible for paying the subs, unless there is something within the contract documents that provides otherwise. So when the general contractor is paid by the owner will typically insist on the general contractor providing lien releases to the owner that the general is going to pay the subs, and the subs aren't going to turn around and file a mechanics lien on the project. That's the general contractor's obligation to make sure that doesn't happen, assuming that there isn't some other dispute going on that would explain why a sub isn't being paid. So the subs have pretty good protection there, in that if the general contractor isn't paying them what they're owed, and yet the owner says, I paid the general, well, the sub can turn around and slap a mechanics lien on that project. And now all of a sudden, the general contractor has to explain to the owner why that happened and how they're going to deal with it.
Yeah. Yeah. So it's crucial to understand who you're working for, right? To really make sure that you have a great reputation in performing. Because sometimes it takes different sectors or different specialists to come together and create this massive project. So the specialty contractors, when they come together, it's the job of the general contractor to really be able to schedule each trade on time and have their delivery at a certain point. But that's the coordination of a general contractor. So let's say there was a concrete pourer that had to come over here, had to come initially, and then a carpenter comes in and starts doing the framework, and then the concrete pourer needs to wait for the framework to be completed to come back for another to complete the project, right? That also happens with painting. That also happens with everything. So if you're working with a general contractor and you're looking for work, you also have to address all these elements of, are you a general contractor that's actually going to make me look good? Or is it, or am I partnering up with someone that's not really going to help me succeed on my company?
And the bigger the job and the more trades that are involved in the job, the tougher the scheduling issues are. And you're right, because every project of construction involves proper scheduling. Everything has to go in the right order at the right time. And of course, a lot of trades depend on other trades having completed their work before they can come in and do the work that they were contracted to do. So there's this very intricate web, if you will, of obligations that these various contractors have to one another in order to ensure the project gets done properly.
So now we have we understand what to do when there's a dispute, how to resolve it. Best way is just peacefully resolve it, and little by little, if they don't listen to you, then that's when you start taking legal action. But how about like the termination clause? What are the things that we need to take in consideration with that particular clause?
All right, so within every contract, there will typically be what you have identified as a termination clause, and that addresses the circumstances in which either side can withdraw from the agreement. And it's important to understand whether under that termination clause, the parties can only terminate the contract for cause or for convenience or for both. Now, what does that mean? When you're talking about terminating a contract for cause, that means for one or more identified reasons, and those reasons have to be spelled out. For example, breach of the contract for failure to make timely payments. That could be a basis for rescinding or withdrawing from the contract. Failure to provide written change orders for additions, revisions, modifications to scopes of work, particularly when it's going to require, as it always does, the payment of additional sums of money to the contractor. In other words, when we say that cause exists, those reasons are spelled out in the contract. These are the events of cause that would entitle one party or the other to terminate the agreement. If it's for convenience, that typically means roughly that either side can withdraw for whatever reason they have, whether they have cause or not. They just decide we don't want to proceed further, we want to terminate the agreement. And of course, the contract will provide for a period of time in which notice has to be given. So it could be 30 days. I'm terminating the contract 30 days from now. Under the contract, then all billing disputes have to be resolved within that period of time. Payment for work performed should be made, et cetera, et cetera. Does it always work out that way? No, of course not. And anytime one side decides to terminate the contract, whether for cause or for convenience, I can almost assure you that the other side is going to feel aggrieved and believe that the contract has been breached in some material respect. And so we may have a dispute that arises out of that, and then we can get into the dispute resolution provisions of the contract.
And these are terms of the contract that sometimes contractors tend to ignore whenever you're evaluating, because these are typical clause on the majority of the contracts that we just swift through it. And it's important to address and understand what they really mean. And that's also part of the negotiation process. You can also think of, what are the benefits and the risk that I'm taking when I'm including these terms. So there's another term that's called indemnification and force majeure. So can you explain those two terms as well?
Sure. So there are two different concepts. Let's talk about each one of them separately. The concept of indemnification is that within the contract, there will be provisions that describe who is responsible for what, and by the same token, who is not responsible for what. So, for example, the owner will typically require the contractor to indemnify the owner from any claims or lawsuits or disputes that might be brought by a third party arising out of the performance of the contractor's work. And this could be as simple as somebody walking by the construction site, tripping on a hose, hurting themselves, and then they turn around and sue the owner. Well, the owner, under that type of indemnity provision that I've described, would say, contractor, you owe me indemnity. You must hold me harmless and step into my shoes and defend my interests against the claim by that injured third party. Now, often owners will try to go really far with these indemnification provisions, and they will want to be indemnified for everything arising out of the performance of the work that the contractor is doing. Now, by implication, that means that the owner is asking to be indemnified from even their own negligence or intentional misconduct. And we'll talk in a moment about a provision of the California Civil Code that basically prevents that from happening. But the point is, you really need to be aware of what these indemnity terms provide and think through with your legal advisor and the other people within your organization what you're buying into by signing off on this contract. One of the points I wanted to make, Andrea, is a lot of people you'll hear talk about terms of contracts as being boilerplate. What is boilerplate? Well, it means it's a standard term that appears in every agreement. Well, ask yourself why. is it a standard term that appears in every agreement? Is it because we're just wasting words and print on a paper? No, it's because it may well have legal significance down the road. And it's always the time that somebody says, oh, we don't need that provision in the contract and take it out, that later on, something is going to arise, which goes back to that very provision that they took out of the contract. And then they wish they had left it in there. Oh, but it was boilerplate. Well, it's not, boilerplate is just it's not even a legal term, but it just means it's a standard term. And the reason it's a standard is because it probably should be in there.
It's happened before.
That's
and it's standard. It's happened enough that it's standardized now, right? So it's most bound to happen in some sort of way. So tell me about this California Civil Code 2782.
So the California Civil Code, as many of you may be aware, is part of the many codes that we have in the state of California, but it typically sets out general legal duties that parties have to one another and rights that they may enjoy in various circumstances. So under California Civil Code section 2782, it prohibits indemnity for another party's sole negligence or willful misconduct. In other words, if I, Kevin Mayer, say, Andrea Navarrete, you need to indemnify me even when I'm negligent or I have behaved intentionally, this civil code provision would say that indemnity provision is void as a matter of law, because we don't want, as a matter of law or public policy, to require people to indemnify someone else from their misconduct. That's number one. It also provides that indemnity should arise only to the extent of actual fault in causing an injury. Let's use an example. Let's say we have a circumstance where somebody gets hurt on the job site and they sue both the contractor and the owner. And the contractor turns around and says to the owner, under the contract, you owe me indemnity for all of this. But it turns out that based on the facts, the contractor is actually 75% responsible and the owner may be only 25%. So at best, according to this civil code provision, the owner would only have to indemnify the contractor for that 25% of actual fault. Now, these are what we call disputed fact issues that typically go to a jury if it ever goes that far. And we know that the vast majority of civil disputes are settled or are resolved by a motion. So you may never even get to a jury to decide these issues, but at least you know that you have certain rights under this section of the Civil Code. It also protects design professionals and subcontractors from overbroad risks. And we won't take the time now to talk about what it is, but if you go and read 2782, you will see how those design professionals and subcontractors' interests are protected from undue indemnity claims as well.
That's really good to know. And speaking of protection, let's dive deep into the last, and I believe it's like one of the most important topics when it comes to protecting yourself as a contractor in projects. And sometimes we don't like it, but we need it, which is insurance, right? Understanding how insurance can protect you and at the same time also help you avoid risk is something clearly important. And there's situations where contractors don't understand that importance. Insurance is related to safety. So if for any reason there's any type of claims, workers' comp claims that you have, which tend to happen, right? In construction, there's accidents. The least accidents you have, the better you're off. But how do you register? And the way a lot of organizations make a decision to secure a contract with a specific small business contractor is through that rating, which is called an EMR, the emergency. Well, I'm trying to think of what the EMR stands for, but it's modification rating. I'm not sure if it's emergency modification rating or something like that. But the idea of the EMR is something that every contractor should understand, and not all insurance representatives and agents are created equal. Not all of them
Right.
understand the nature of construction. Can you elaborate a little more on that, Kevin?
Yes. So as you recall, I mentioned earlier that everyone should have an attorney, an accountant, an investment advisor. To that, I would add everyone should have an insurance agent or broker. And that
Yeah.
person needs to be well versed in your industry, in your profession, and advise you as to what sort of insurance coverage you should have at minimum to protect you from risk. What risks are we talking about? Well, it's the risk of being sued. It's the risk of a claim being made against you for money, because that's usually what it's about. So, for example, in the contract, there will typically be insurance requirements that are spelled out in specific provisions of the agreement. And as a contractor, you will typically have three basic types of insurance, including what's required by law. So you need a comprehensive general liability policy. You need an automotive policy if vehicles are being used in the performance of your profession and people get into accidents as they do. And you need a workers' compensation policy, which is actually required by law. If you have employees, you need to have workers' compensation coverage for those people that are injured in the course and scope of their employment. So why do you need these things? Well, worst case scenario, something goes wrong on the job, the owner turns around and sues you, claims breach of contract. Do you want to have to respond to that by retaining an attorney out of your own pocket? Or do you want to be able to tender that claim to your insurance carrier, have the carrier step in and provide for both your defense and hopefully your indemnity? So there's two parts of a claim. There's the duty to defend and the duty to indemnify. And the duty to defend is they actually have to provide for your legal defense. They have to provide an attorney to represent you in addressing the dispute. And the duty to indemnify is under the terms of the policy. Does the policy actually cover the claim that has been made against you, assuming that it can be proven and it's proven to be your fault? So that's why we have insurance.
Yeah. And you gotta and for contractors, it's not only that type of insurance, but there's also bonding requirements that are stipulated in the contract. You
Yes.
gotta make sure that it's sometimes your contract won't even be, or your submittal won't even be considered if you don't show the proof that you have a performance bond. You gotta have there's three types of bonds, right? In a contract when you're also already pursuing larger contracts, and that's a complete other topic, because we can spend so much time just talking about bonding, insurance, how to protect yourself, how to read that, how to select the right surety agent, the right insurance agent for yourself. But it's something that you in the contract you really need to consider if that's something that you can absorb, if the insurance policy is going to interfere with a lot of your cost that's involved on the project. So
Right. And that should be built into how you price your bid. Obviously, you have to take into account what the actual costs are that you're going to incur, what your profit margin is, how much you're going to have to pay subs, what your insurance costs are, et cetera, because you don't want to end up losing money on a job. You want to make some money. I mean, that's the whole point.
right,
That's why we're in business. We're here to make money. It has to be
exactly.
a fair return on your investment of your work. So you have to make sure that all of this is taken into account when you're bidding a project.
Well, Kevin, I think our time's up, but I think we made the best use of it. We hit a lot of the topics that are critical when evaluating a proposal. And for the audience that's looking at us and they're like, how do we start? If you really want to understand if this particular project is for you, before even submitting a proposal, there is a filter process that your company can create, right? And that filter process is specifically according to identifying your capacity, knowing what your specialty is, understanding your niche. If I look for you because I got in trouble with the law and I got arrested, you're not going to be able to help me, right? You're going to be able to tell me is go with a criminal lawyer that's local to that area, right? So it's the same thing with construction. A contractor, even if you're a general contractor and you feel like you can do everything because you know perform a certain area, but you sub out the rest, you got to understand that it's not only that component, it's the specialty, the area that you're in that you can say I outperform. That's why history performance is so important and critical when evaluating when a person is deciding on getting on who gets awarded, right? If in case you contractor want to understand and learn a little more about how to filter that process, how to have a document where I can identify if this is a project for me or if it's not a project for me and it's only a waste of time, you can always reach out to us. Minorea-BEM is here to support you in every step of the way, from understanding how to become contract ready to how to identify and get awarded a project and how to perform on project. And Kevin is one of our troopers that supports us on all on this complete endeavor that you have to take. So if you want your free filter document, make sure to reach out to us. Make sure to like and subscribe our channel and participate here every Wednesday, third Wednesday out of the month. We're going to have these sessions and we're going to have these great conversations that are related specifically to the projects that you're interested in. I think that's it. Anything else you want to address, Kevin?
No, it's been a real pleasure, Andrea, talking with you this morning. And ladies and gentlemen, I hope this has been helpful to you. We're always available to chat about your legal issues and provide advice and steer you in the right direction. So feel free to reach out whenever it's convenient and necessary.
All right. So I think that's it. We'll see you next month. Remember the third Wednesday at 8 a.m. of every month. This is your platform. This is your space to ask us whatever you want and to address all the topics that we know that is going to be in your plate whenever you get secured that next project. All right, Kevin, have a great day. Everybody, have a great day. And we'll see you next time.